Okay, we have a circumstance scenario here today to cover and what needs to be done. Married, one child, home, and business. Where do we start? Was the question. Before I get to the layout of an estate plan that could be appropriate with these few variables, I'd like you to think about a friend who's challenged with a what-if scenario that creeped into their lives. But they were somewhat prepared because you shared this video. We would appreciate it, as will your friend. I'm Valerie Zammitti, an estate planning attorney in New York and New Jersey, and we're here to educate everyone for free. So please drop your questions for us, and hopefully we'll help some folks along the way. Now, for absolutely everyone, married, single, kids, no kids, if you're over the age of 18, you need to start with incapacity planning documents. If something happens to you and you can't make financial or health decisions, you need to have those 4 essential documents. Financial power of attorney, designating who is going to help you with banking and insurance and taxes and all of those things. 2, we need to have a health care proxy, sometimes called a power of attorney, to designate your medical agents to help you through any kind of general medical choices. That agent also will then follow through with the wishes you designate under your living will. It's also sometimes called an advance directive. Those are the wishes that you designate that if you're ever found in an incurable, irreversible state with no chance of recovery, what you would like to have be done with the excess means that are attached to keep you in that state. And lastly, a HIPAA authorization is the last incapacity document, simply the release of medical records to your trusted parties so that they can help make the right medical choices for you. In this scenario, married, 1 children, you have a home and a business. Clearly, you need at the very minimum a last will and testament. However, in your scenario, I would advise typically that will is just a backup document, a very basic one that says, hey, we somewhere along our lifetime forgot to put our assets under our core estate plan, which is a trust. Okay, I'm not going to talk about which trust because I don't have enough information to share that, but just put it under the umbrella of a trust. And so that will say everything flips to the trust at the end of the day. Because your child in this particular scenario, the individual who provided us is fairly young, I'm going to say that you may not be at the stage of needing asset protection just yet, maybe. So if we're talking about a trust, let's say a revocable living trust, okay, a revocable living trust becomes your core estate planning piece. You are going to want to fund all of your assets either immediately into that trust or make sure it is a beneficiary designation to that trust, okay? Your home should be transferred to that trust immediately. We're talking about a revocable living trust. And this is key, anyone with a small business, you want to make sure that you transfer and assign the interest from you as an individual to your trust so that the business interest doesn't go through a probate process. That is really important. And it's key that the transaction follow all the business rules and regulations. You have proper paperwork updated within the business, such as a resolution, a new operating agreement, updated certificates for that business. And of course, the assignment showing that it's no longer you as individuals, but you as the trustees of your trust. That's a really important piece when you do have a business interest. And that's one reason why a revocable trust is probably a stronger type of estate plan for you. I hope that's helpful to more than just one person and that you choose to share. As always, please take care.